Good afternoon, this is Sean Golding with Golding & Golding, expanding on our prior presentation focused on permanent residents, green card holders. Let's focus on visa holders and whether they have to pay U.S. tax on their worldwide income and what they could do to avoid, minimize, or eliminate taxes. So again, the U.S. taxes individuals on their worldwide income. Individuals includes U.S. citizens, lawful permanent residents, and foreign nationals who meet the substantial presence test. Typically, this is going to be visa holders. You're a work transfer L1, or you're here on an H-1B, or you're a tourist, hospitality tourist B1, B2, or you're here on like a treaty investor visa, E2 or E3 for Australia. Any type of visa, or even non-visa, but again, primarily it's going to be visa holders. If you meet the substantial presence test, you're taxed on your worldwide income. It essentially means that you're here for a certain number of days in the current year and the 2 prior years. It's combined into a 3-to-1, 6-to-1, and 1-to-1 ratio. You mix it all in a pot, and if you meet the threshold requirements, then you meet substantial presence and you're taxed on your worldwide income. Now, there are some exceptions, which we'll get into in a moment. There's the closer connection exception, for example, which means if you have a closer connection to a foreign country or foreign countries, you may avoid substantial presence, although you have to do it before you apply for a green card in case that's something you're considering, because that negates the exception. There might be some treaty rules. You may be able to make an election. You may qualify under certain situations, like you're here as a researcher for 2 years and things like that. But again, baseline perspective, if you're a visa holder, you meet substantial presence, you're taxed on your worldwide income. So what does that mean? It means whether or not the income is sourced in the United States or sourced overseas, whether you live in the United States or you split your time between the United States and a foreign country or multiple countries, all of your income is taxable. This is true even if it's sourced overseas, even if you keep it overseas, even if it's taxed overseas. If all of your money is from overseas, you still have to file U.S. tax returns and pay taxes on your worldwide income. Now, you may qualify for foreign tax credits in order to reduce or eliminate your U.S. tax liability. There's something called the foreign earned income exclusion, but that requires that you live in the foreign country for most of the time, and if you did, you probably wouldn't meet substantial presence in the first place, but mainly for permanent residents and citizens, they may qualify for the foreign earned income exclusion. Few important facts about having a visa and substantial presence. When you have a green card, it's much more complicated. Whether you live in the U.S. or not, you're still taxed on your worldwide income, even if they won't let you back in the U.S. With substantial presence and visas, it's a bit different. If you don't meet the substantial presence test in the current year, then you don't have to pay tax on your worldwide income. That's the general rule. So even if you were here for 200 days in each one of the past 2 years, but in the current year you're not in the U.S. for at least 31 days, you won't meet substantial presence and you don't have to pay tax on your worldwide income, so it's easier to plan around. Employment and non-employment visas are treated the same. A lot of times you get questions, well, I don't work in the U.S., I'm not on an L1 or H-1B, but I have a tourist visa and I visit, 3 to 4 months, 5 months every year, but I don't earn any income in the U.S. Unfortunately, the tax purposes, it doesn't parse out that way. If you meet the substantial presence, even if it's not a work visa or employment visa, it still qualifies. Now, one very important thing is planning. So if you're planning on coming back and forth between the United States, or you're here on a visa and you're thinking it may just be easier to get a green card, you have to consider how long you're going to be here for and what your worldwide wealth is and your income, because you could become subject to the exit tax later if you end up getting a green card. So having a green card can be easier, right? Especially if you're planning on living in the United States for at least 6 months out of the year, because you don't have to reapply every year, every other year for the visa. Typically, the green card will last 10 years. Back in the day, there was unlimited, but now it's pretty much 10 years. But you could become subject to taxes when you give up that green card, so that's something to consider. If you're out of compliance and you want to get into compliance, there's various programs available to you. If you're willful, there's the voluntary disclosure program. If you're non-willful, there's programs such as the streamlined procedures, delinquency procedures, and reasonable cause. We got a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.